Fox Alert, we're going to get out of that commercial break because we have word that the Supreme Court has issued a ruling on the extent of presidential immunity from criminal prosecution for conduct alleged to involve official acts during the tenure of President Trump. This is the big one we've been waiting for. It's consequential. It's really interesting that the Supreme Court in 248 years of our history has never actually ruled on this. So it is big and sweeping. And I have our political panel looking over this right now. Andy McCarthy, Chief Justice John Roberts has the writing on this. He's got the pen. Is that significant?
It's very significant. It's the most important case of the term in terms of the long-term interests of the executive branch, in terms of the short-term interests of Donald Trump. And it looks like, at least within the bounds of clear executive authority, what Chief Justice Roberts is saying is that the president clearly has immunity from prosecution. So the question is going to be, again, I think Trey underscored this before, is what is an official act? There's going to be a lot of litigation about that, and what's close to the core of clear executive constitutional authority versus the outer ambit of it.
The wins just keep coming. They finally did it, gang. The Supreme Court has ruled that President Trump does indeed have wide-ranging presidential immunity. We've got the latest and, of course, what it all means for the future of Democrat lawfare against the soon-to-be number 47. Hey, gang, it's me, Dr. Steve, your Patriot Professor, here to help you stay sane in these insane times. So make sure to smack that bell and subscribe button. Also, you all know that with Biden at the helm, government overreach is at an all-time high. The agencies that we used to put our trust in are now turning against us. Even the FDA, the Food and Drug Administration, which is supposed to keep us safe and protect public health, it's turning against us. They're trying to keep NMN, an essential enzyme vital for metabolism, DNA repair, and cell growth, away from us. They're trying to suppress a supplement that's revolutionizing health. But why? Well, it's simple. A healthy population is harder to control. The current administration doesn't want you to get stronger, get better results on your health and fitness journey. But courageous patriots like Black Forest Supplements remind us that we never back down. It's time to take control of your health and get stocked up on NMN to show the left we can't be stopped. I love Black Forest Supplements. I take NMN every single day, and I'm so grateful in knowing that I'm supporting a company that's actively fighting the FDA. But not only are they fighting the crazy woke liberals, the patriots at Black Forest Supplements are giving Turley Talks listeners a huge discount on NMN. For the next 48 hours, they're offering a buy two, get one free deal. You heard that right. Buy two, get one free. That's just for the next 48 hours. So don't sit on this one. Go get your NMN now and get your health out of the hands of Big Pharma. Click on that link below right now and get your NMN, and let's fight back together. In a stunning 6-3 decision, the Supreme Court has just ruled that presidents are indeed immune from criminal prosecution for official acts as President of the United States, according to the majority opinion written by Chief Justice John Roberts. Quote, at least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. Now, as expected, the Supremes ruled that there is no immunity for the presidential's unofficial acts, so there appears to be some ambiguity here. The court has instructed the lower trial courts to hold specific evidentiary trials on each criminal count against Trump to determine which counts, if any, apply to non-immune acts. So again, at the very least, every single one of Trump's cases are going to have to now go through a review, and they may indeed end up imploding as a result. Here's my namesake, Jonathan Turley, on the legal implications of this stunning decision.
In reading through this opinion, I can't see how this doesn't induce cardiac arrest with the special counsel. At one point in the opinion, they say, look, this is a quote, the indictment's allegations that Trump attempted to pressure the vice president to take particular acts in connection with his role with the certification proceeding thus involve official conduct. And Trump is at least presumptively immune from prosecution for such conduct. The court then goes on to say that the burden, of course, is on Jack Smith. He has to show that this does not pose any intrusions into the executive branch. And the court says that that this, quote, may well hinder the president's ability to perform his constitutional functions. So here the court is imposing a very significant burden on Jack Smith when this goes back to the judge. We talked about how this trial judge has proven to be very favorable towards Jack Smith. She's certainly been motivated to try to get a trial before the election. But the court here is giving much more clear lines than some people expected. They're saying that there is a presumption here that you have to deal with. The burden is high, and the court indicates that it may view this as something that could hinder a president's authority.
Translation: Jack Smith's J6 case against Trump is toast. Whatever Trump did regarding the vote certification process in Congress on January 6th was fully in the context of his official duties as president. So it looks like the J6 case has exploded in Jack Smith's face. And almost certainly the Fulton County case, the Big Fannie Willis case, is done based on the same parameters. We'll have to see what happens with the other cases here. President Trump could not contain himself. He was so excited. He just posted on Truth Social, quote, "Big win for our Constitution and democracy. Proud to be an American." Now, this is actually the second huge ruling in a row coming from the Supreme Court. I don't know how many of you caught the ruling a few days back regarding what's called the Chevron deference rule. That was gigantic. Now, if you don't know what the Chevron decision is, back in 1984, it's what's called the Chevron versus Natural Resources Defense Council case. The Supreme Court ruled that courts basically had to give deference to federal agencies as the experts when it comes to creating regulations based on an ambiguous law. So what that means is that Congress routinely enacts open-ended laws, like, say, some vague environmental law, right? And then what they have to do is they give huge latitude to regulative agencies to work out the details. And they can continue to change and adjust those details as time goes on. So this is why regulatory agencies have had so much power. The Supreme Court, in what's called this Chevron decision back in 1984, they gave regulatory agencies almost unlimited power in that there was no legal recourse to challenge their regulations. The Chevron decision basically made regulatory agencies the experts in their respective fields, and the courts were basically required to just defer to the regulatory agency's interpretation of the ambiguous or vague laws passed by Congress. So what this means is that over the last 40 years, federal agencies have been able to, quote, interpret laws to mean whatever they want, and the courts basically just had to go along with it. That's why the legal practice was called Chevron deference, and it put bureaucrats, unelected bureaucrats, in charge of the country. That's how OSHA, right, the Occupational Safety and Health Administration, remember this? That's how OSHA was able to mandate that everyone who worked in a large company, right, with 100 employees or more, had to get vaccinated or else get fired. No law gave OSHA that authority. OSHA regulatory official, unelected regulatory officials just made it up. Now, of course, that mandate, that OSHA mandate, got smacked down by the Supreme Court a couple of years back. But now, as of just a few days ago, the Supreme Court actually overturned the very decision that gave OSHA that kind of deferred authority in the first place. And so now we finally have a legal recourse to push back against the federal regulatory apparatus. It was a glorious decision. And if you want to see how out of touch our ruling class is, take a look at this tweet from the ultra-leftist Harvard law professor Lawrence Tribe. Look at this. "The ones I feel sorry for are my administrative law colleagues who built their courses and careers around the intricacies of Chevron deference." Now make sure what you just heard, that you understand what he just said there. This law professor is lamenting over the job losses among lawyers that are going to come from the Chevron decision. If that doesn't show you how far removed our political class is from average law-abiding constitutional citizens, I don't know what does. And of course, this loopy, loony liberal law professor got absolutely savaged online. Liz Wheeler responded, yes, the real victims of Chevron are certainly the lawyers who help write and enforce unconstitutional technocracy. Another responded, constitutional rule is reestablished and you feel sorry for the lawyers? My God, man. And Tom Woods, I already support the Chevron decision. You don't have to keep convincing me. So the Supreme Courts have been on a roll here. They've been dishing out some huge wins for the integrity of our constitutional republic, making this presidential immunity win all the more sweet. Here's your opportunity to tell big tech tyrants where they can stick it. Click on that link below and download our brand new cancel-proof Turley Talks app, and you can sign our special declaration of restoration. That's our petition to big tech that declares a new day is dawned. They are no longer in control, and we are taking our nation back. We've already got over 1,000 signatures of courageous patriots, and yours is next. Click on that link below or go to fight.turleytalks.com right now.